Erev Tov Rabotai, we are continuing with our Mishna Yomi Masachet Sanhedrin. We are up to Parakeh Mishna Gimel. Today's Mishnayot should be Le'ilu Nishmat, Neria ben Svetlana, Ranbai, Eliyahu ben Burcha Israelov, Chana bad Miriam, Sason ben Raya, and Yoshua ben Shifra, Menuchatam began Eden, Amen, and Avdi ben Chaim lechaim, v'derefua shenemav Daniel Shalom ben Rosa, betoch Shachol Israel, and Achlama Merav Binamin, Od Zion Chai ben Dvorah. The previous Mishnah taught that if witnesses give contradictory answers to questions asked by the court, their testimony is invalid. This Mishnah teaches that in some cases, however, even if witnesses give different answers, their testimony stand because we may assume that they meant the same thing. Echad omer b'shnayim b'chodesh, if one witness says that the crime occurred on the 2nd of the month, v'echad omer b'shosha b'chodesh, and the other one says that it occurred on the 3rd of the month, edutan kayemet, their testimony stands, because we assume that this is what happened. The day had been added to the previous month, meaning it was a 30-day month, and not a 29-day month. The first witness knew about the addition of the 30th day to the previous month, but the second witness did not know about the addition of a 30th day to the previous month. Rather, he thought that it was only 29 days long. Therefore, when the second witness said the 3rd of the month, he was referring to the day that was actually the 2nd of the month, which is what the first witness said. Therefore, they are in agreement. Since such a mistake is common, we may reasonably assume that this is what the second witness meant. We can therefore solve the contradiction in this way and allow their testimony to stand. Now, we do not automatically assume that the witnesses are contradicting each other and one of them is lying. Instead, we attempt to find a reasonable solution of the contradiction. In the Mishnah's case, where one witness said the 2nd of the month and one said the 3rd of the month, we propose that the crime actually took place on the 2nd day of the month, as the first witness said. When the second witness said the 3rd of the month, he too meant the 2nd day because he mistakenly started counting the days of the month one day earlier than he should have. And this understanding of his words is reasonable because people often make this type of mistake, as the Gemara explains on page 69 in Masechet Sanhedrin. Furthermore, both witnesses agreed about the day of the week. They disagreed only about the day of the month. For example, one said that the crime occurred on Sunday the 3rd of the month, and the other said that it occurred on Sunday the 2nd of the month. This makes it all the more likely that they refer to the same day, and that one counted the days of the month wrongly. If, however, they said 2 different days of the week, they must be contradicting each other, because people do not confuse the days of the week. In that situation, their testimony would be rejected, as the Kesef Mishnah writes in Echod Edut, chapter 2, Halakha 4. The Mishnah's case is that the previous month was 30 days long. However, the same law would apply where it was only 29 days long. We would then propose that the witness who said the 3rd day knew that the previous month had 29 days, whereas the witness who said the 2nd day thought that it was 30 days, and therefore started his count a day later. In the following instance, though a difference in the date does disqualify the testimony, Echad omer b'shlosha, if one witness says that the crime occurred on the 3rd of the month, V'echad omer b'chamisha, and the other one says that it occurred on the 5th of the month, edutan b'tela, their testimony is void. A difference of 2 days cannot easily be explained. We must therefore accept that they refer to different days, which is a contradiction that makes the testimony invalid. The Mishnah discusses what happens when witnesses disagree about the hour of the day. Echad omer b'shtei shaot, if one witness says that the crime occurred in the 2nd hour of the day, v'echad omer b'shalosh shaot, and the other one says that it occurred in the 3rd hour, edutan kayemet, their testimony stands, because we assume that both saw the crime at the same time, and one of them made an honest mistake in reckoning the hour. In the times of the Mishnah, when people estimated the time by looking at the position of the sun in the sky, such errors were common. Echad omer b'shalosh, however, if one says that it occurred in the 3rd hour, v'echad omer b'chamesh, and the other one says that it occurred in the 5th hour, edutan b'tela, their testimony is void, because a person is unlikely to make such a great error. The next Tana disagrees with this last ruling, Rabbi Yehuda Amel, but Rabbi Yehuda says, kayemet, their testimony stands, because people often confuse even the 3rd and 5th hours. Now, in the next case, everyone agrees that the testimony is void. Echad omer b'chamesh, if one witness says that the crime occurred in the 5th hour of the day, v'echad omer b'sheva, and the other one says that it occurred in the 7th hour, edutan b'tela, their testimony is void, even according to Rabbi Yehuda, sheb'chamesh chama b'mizrach, because in the 5th hour the sun is in the east, uv'sheva chama b'ma'arav, and in the 7th hour the sun is in the west. An hour in this context is not 60 minutes, but a 12th of the day from dawn to nightfall. Therefore, the 5th hour is always before midday, when the sun is in the eastern part of the sky, and the 7th hour is after midday, when the sun is in the west. Since it's easy to tell the difference between these 2 hours, people do not confuse one with the other. Therefore, they must be referring to different hours, which is a contradiction that makes their testimony invalid. And that is that of Mishnah Gimel. Mishnah Daled returns to its description of the procedure for capital crimes. V'achakach, and after the judges question the first witness, as described in Mishnah 1, machnisin et hasheni ubotkin oto, they bring in the second witness and they examine him with the same questions. If the statements of the two witnesses are found to be consistent and their testimony is accepted, the judges open the case with a statement of acquittal, meaning they tell the defendant that if he is innocent, he has nothing to fear because he will be acquitted. The Mishnah teaches who may make arguments in favor of the defendant and who may make arguments against him. Amar echad min ha'edim, if one of the witnesses said, Yesh li lelamed alav zechut, I have a reason to acquit him, or echad min ha'talmidim, or if one of the students who sit before the judges said, Yesh li lelamed alav chova, I have reasons to convict him, mishatkin oto, the court silences him. A witness may not join the discussion at all, either on the side of the acquittal or the side of a conviction, and a student may argue only for acquittal, not for conviction. We learn from a verse in Bamidbar, chapter 35, verse 30, that a witness may not participate at all in capital cases. The same verse teaches that a student may not argue for conviction. The Mishnah relates what happens when a student argues for acquittal. Amar echad min hatalmidim, if one of the students said, Yesh lamed alav zechut, I have a reason to acquit him. Ma'alin oto, moshivin oto benehem. The judges bring him up and seat him among themselves so that he can present his argument to them. V'lo haya yored misham kolehem kulo. And once a student is seated among the judges, he does not go down from there the entire day. Even if it's no longer necessary for him to be there, we allow him to stay for the rest of that day because it would be embarrassing for him to return to the student's row in front of everyone. Now, the Mishnah refers to a case where the student's argument was found to be wrong. He then stays with the judges only until the end of that day. If his argument is valid, he is given the honor of sitting with the judges permanently. However, he does not vote with them. If there is something to his words, meaning his argument seems to be sound, Shamino, the judges listen to him and discuss what he has to say. Moreover, the defendant himself can argue for his own acquittal. Even if the defendant says, I have a reason for my acquittal, they listen to him, but only if there is something to his words. And that is the Rabotai of today's Mishna Yomi. Baruch Adonai Le'olam. Amen v'amen.